Hello, hello. I'm attorney Kirsten Hildebrand with Hildebrand Law Firm, and I have today our business attorney who is here, a partner of mine, Mark CLAUSS. And we have together decided that it is really important for you to get some information if you are a business owner. And as a business owner, if you have any agreements with employees, such as, and specifically agreements related to not competing under certain circumstances, generally known as non compete agreements, or sometimes they're referred to as something else, but generally speaking, they have provisions in them that do several things. And the main five components of a non compete agreement in Wisconsin include the following. Number one, the employer has a protectable interest that justifies having the restriction in place. Secondly, that the restriction has a reasonable time limit. Thirdly, that the restriction has a reasonable territorial limit, and sometimes that can be really difficult to define. The restriction is not harsh or oppressive to the employee. And fifthly, the agreement is not contrary to public policy. Well, there are several of those elements that have now been called into question on a overall national level, and we have to look at these agreements now much differently in Wisconsin. Mark, tell us a little bit about that.
Thank you, Kirsten. So, as a matter of fact, actually, all of those elements will be off the table here soon. All non-competes will be banned as of September 4th. Last week, the FTC announced final rule regarding non-competes. The idea was that they believe that this will inspire additional competition. It will grow the economy. More people will be able to get jobs. They'll be able to get better jobs. There will be more intellectual property. There'll be a lot more patents. They estimate this law will affect over 30 million United States employees, and it should not have negative effects on the employers. We will see about that. So, as I said, this was just voted in last week on April 23rd. It was a 3-2 vote down party lines.
And where was the voting? When you say voting, what does this mean?
So this is the Federal Trade Commission. So
Okay.
it's a commission of 5 designated federal government department heads who make rules so that the law that the FTC is supposed to protect is anti-competitive laws coming out of the Sherman Act in the 50s. So Section 5 is the protection against unfair competition. So that's where this rule that they created stemmed out of. So they came up with the rule actually a year ago, and they submitted it to the public. They had over 26,000 comments on this rule, and it was split pretty evenly and pretty strongly about this is not fair, this is bad, this is good. After that time period was up, they had a vote, and it passed 3-2. So
fascinating.
Passed on the 23rd.
So one
correct.
person has changed the entire legal landscape for employers with respect to
The entire United States.
in the entire United States, and all agreements that have any sort of non-compete language in them. That is really something, isn't it?
That is correct. So the language did change a little bit during that period. So the final rule is pretty much brand new, and all the lawyers in the land are getting their taste of it right now. It will become effective after a publication period. Publishing starts on May 7th, and you add the 120 days, that gets you to September 4th. So if nothing happens between now and then, on September 5th, non-competes will be banned as a matter of federal law, with a few minor exceptions. But generally, if you are a for-profit company, you can't have a non-compete agreement. So what does that mean?
Yes,
well,
that's a big
first,
shift.
let's say
it?
September 4th is the official day.
Yeah.
Unless something slows that down. There have already been 5 lawsuits filed, 3 of which are in different federal courts. So it's inevitably going to have some delay, just because the federal court and the split is going to have some discussion and want to figure this out. So while that's the date, everyone knows it's probably going to slow down a little bit. So what do you do between now and then? Kind of what does this mean for employers in Wisconsin? Well, first of all, those elements we were talking about before, those are the Wisconsin rules for non-compete agreements.
Hmm.
Wisconsin has a statute that's liberally construed in favor of an employee because everyone wants people to work. You know,
Hmm.
the whole idea is you don't want to stop people from being able to go get a job. So it isn't to bar folks from who get fired from not being able to work again. It's to they have to show how that bar protects something special about the employer. You know, and trade secrets and confidential, privileged, proprietary information, that's still protectable. There are still, you can still have all of those agreements and
Hmm.
protections and NDAs. All of those covenants can remain in place. You just can't stop someone from getting another job.
Hmm.
So when you do, currently in Wisconsin, that five-factor test lets the Wisconsin court, under Wisconsin statute, say you can bar people, but only for a little bit of the right amount of time and in the right amount of way. Like you can't, if it's a salesman who sells cars and you want to bar them from getting any job, well, you can't do that. And Wisconsin says if you overstep, the whole contract is thrown out. Everything,
And
not just a little part of it. So if this is combined with a lot of other things, you lose all those other things too. So it's important to have these be kind of separate individual covenants and perhaps under separate signing. So if it does go, you can still protect all of your other assets in a different way. So in that explanation, I was saying you would have to limit that car salesman only for a certain amount of time in a certain area that that dealership would have been selling. You can't stop him from selling in another state or maybe even a few miles or hours away or, forever.
And
So
even within
those
that
limits,
context, right? Even within
exactly
that
right.
context, there's still a lot of ambiguity because in Wisconsin, every single case says these sorts of things are highly disfavored. And that's
Correct.
the phraseology that's used in the case law. So employers have always sort of had the wind in their face when it comes to actually enforcing these agreements. But on the employee side, and we have represented a lot of executives who have signed these sorts of agreements. And the question is, do we want to besmirch our reputation by taking this type of stance against a former employer and go work for the competition, thinking I'm going to have to look over my shoulder for the next however long in my career to determine whether or not I'm going to be sued as an executive who left company A and now is at company B? Are they going to consider that to be a violation of my non compete agreement? Yes or no? So there's just a lot of complication that has happened with this. And in a certain sense, I think that the FTC is trying to essentially simplify because it has resulted in considerable litigation and also people making life decisions. So this perfect job comes up that's with a competitive company. Instead of going to that competitive company and accelerating my career as an executive, now I have to go over to a totally different type of, say, product that is being sold in a different type of company, learn all of that because I can't violate my non-compete agreement, which may or may not be valid, but I don't want to find out because I don't want to be involved in litigation and have my name blasted everywhere that I'm the one that might have violated my non-compete agreement. So these are the real world situations that we have come in here at Hildebrand Law Firm, and it's fascinating to me that this is now completely upended. But the real question I have, Mark, is what should employers be doing? Should their position be, look, this is probably not going to happen anyway, so let's just carry on and continue to offer non compete agreements? Or would your recommendation be to start moving in the direction of really protecting employers from what is inevitable in the future?
Good question. And there are a lot of different circumstances. I guess, first of all, the FTC rule actually places a burden on all employers to notify every employee who happens to have a contract.
Oh,
There's an affirmative act that they have to tell you you have a contract, and guess what? It's not enforceable anymore. And it has to be a particular notice. It has to be good enough that the person knows A, they had a non-compete, and B, it's unenforceable. So that has to happen before the effective date. So right
interesting.
now, every employer has a federal law that requires them to notice all of their employees and tell them, we have a contract that I'm not allowed to enforce. So that currently exists as an affirmative requirement on all employers in the United States who are for-profit entities. So all employers should be looking now at, who do I have an in-force agreement with? What do I even have an in-force agreement? I didn't know it. Did they sign an employee handbook?
Mm,
And is there a provision in that handbook that says if they
hmm.
leave, you should be looking at these things, because now the employer, instead of being on the offense saying you can't compete against me in this other field, is now going to get sued by having provisions in their handbook. And if it's too, if even if it exists, they lose. Rather than, is it too egregious or not egregious enough or under the circumstances, now you're on the defense. So employers should be looking at how they treat their employees and under what circumstances are they restricting their employees' future employment, and what, for what purpose. So trade secret law still exists, confidentiality laws still exist, NDAs still exist, and frankly, there's a lot of practical things you can do when you know an employee is leaving, whether it's a key employee or someone who had access to those items.
Hmm.
So there's a lot of things we can do to talk about practical onboarding and offboarding when someone is about to leave and you know they have access to certain things that, if they use those, could harm your rights as an employer in intellectual property, in certain relationships with customers, client lists, the ways with which you do your the ways with which you conduct your business. So I guess, for example, it would be ideal to have a sit down with that employee and give them a list of expectations of things that they are not allowed to share, and have them sign and agree to a confidentiality agreement that, yeah, if I'm going to go out and get a job in this same industry, I specifically will not XYZ. And if they sign off on that, at least you now have an affirmative, they knew that they weren't supposed to do this and they did it anyway, which
Hmm.
is a very different case
Hmm.
from, oh, I didn't even know I couldn't. And then,
Right,
and
right.
suppose they don't sign it. Well, that says something too. That
Yes,
says they know they're going to violate their confidentiality if
right.
on the way out they refuse to sign something that they may have signed when they onboard.
Sounds like
So
there's a
there's a lot we can do
lot.
here.
Exactly. It sounds to me
Exactly
like
right.
number one, I think our advice would be call us because there is a lot of complication here and there's too many different circumstances for us to issue flat out here's what you should be doing in all circumstances. It really is an employer by employer and maybe even an employee by employee situation. And so call us because we are front and center on this issue and we can help with figuring out how to communicate, what to communicate, and then what your agreements should look like in the future. And then I would say, secondly, don't do this on your own because there's too much at risk. It seems to me that when you have a governmental entity that is giving the employees full power to sue and receive what appears to be, maybe, is it a fine that they would be fined with, or what would it be if they
So,
continue, if they don't give notification, what happens is the question.
well, that's the rub, and that's part of why these lawsuits have been filed within hours of the rule being announced. Um, if you think about, Section 5 of the FTC Act, that's the non-compete, or that's the fairness in competition section, as
Mm-hmm.
opposed to having it come out of a consumer protection area. So from a federal level, that's basically saying it's pretty clear they can get an injunction. So that means you can ask the court to bar somebody from doing something.
Mm-hmm.
It's unclear whether you can go get money for damages for that. on a federal level.
Hmm.
Aha, but Wisconsin law and statute, which didn't go away and didn't change,
Yet.
if you violate a federal law, well, all of a sudden you violate the Wisconsin law, and now under Wisconsin statute, you can go ask for money for violating some other rule in the catch-all sections.
So you basically
So,
want to stay away
right,
from
the
that.
combination of the existing Wisconsin laws,
Right.
which frankly, it was state by state, and these have been on the books for almost 100 years in a
Right.
lot of different places. So there's a lot of law, and every state's a little different. Employers that have employees in multiple states have to treat people a little differently. And so it's very individual, but there's a lot you can do. And there's some best practices we can put into place. And there's some procedures. And that if they're used in the right way, I think you can give yourself the most opportunity to protect ultimately the items that you want to protect, whether it's a trade secret, secret recipe, a client list, certain things that are unique to your business and
Hmm.
special things that you don't want to get out in the world that would inhibit your ability to continue your business. There's just so many ways we can think about adding protection for you. And a lot of times it goes down to a relationship with particular employees
Yeah.
and how you finesse that particular situation. So we'd be
Awesome.
glad to talk to you about that here. Go through your employment handbook and all of your policies in this regard and give you some advice in that
I think the
way.
I think the bottom line is we can't stress enough how important it is to pay attention to this as an employer, and that's why we are jumping on right away and letting you know, as our clients, as our current clients, and as potential future clients, that we are really wanting to make sure that you are protected from having something unfortunate occur by not paying attention to this really important development. So thank you so much for joining us. We are here for your today and your tomorrow, and we will talk with you next time about other really important legal developments.
Thank you.